was fine. So that's all you got.
Yeah. Hey, stop. Thank you for the camera. Just so. How are you doing? Good.
It was fine. So that's all you got.
Yeah. Hey, stop. Thank you for the camera. Thank you. Just so. How are you doing? Good.
It was fine. So that's all you got.
Yeah. Hey, stop. Thank you for the camera. Thank you. Just so. How are you doing? Good.
We're good.
That was it. Yeah, a lot.
Okay.
All right, we're good.
The answer is two.
Andy, do you want me to start?
Yeah, go ahead.
Howdy.
I think we're good to go. Yeah, like technically, I think we'll start at, yeah,
Can I ask as far as the taping, is it gonna take yours?
it's just gonna do the screen and then the mic.
Okay.
But first up, I think is just a roll call and then we have, we have some minutes to do, and then we'll be.
So I'll call this meeting the Undergrowth Planning Association to order at 5:31. I'll see, we're still in pledge.
The Republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, next up on the agenda is call the roll.
Chairman Michelle,
Here.
Commissioner Albrecht, Commissioner Mitchell, Commissioner McDonough.
Here.
Commissioner Nina.
Here.
Commissioner White.
Here.
Commissioner Sutton. Thank you, we have a quorum.
Right. Next, I'd like to entertain a motion to, well, first, are there any corrections or changes to the August 4th, 2025 meeting minutes? Seeing none, I entertain a motion for approval of the August 4th meeting minutes.
I will second.
I'm sorry, who did first? Okay.
All right, I'll do votes.
Roll call. Commissioner Nina.
Yes.
Commissioner Schleichman.
Yes.
Chairman Michelle.
Yes.
Commissioner McDowell.
Yes.
Thank you, motion carried.
Now I just turn over to you guys.
All right, thank you, Chairman. The staff and I thought it would be a good opportunity for us to go over some basic zoning concepts, how we derive our powers, and to try to answer any questions that the Planning and Zoning Commission members may have as we go through this. And even if something's not on the slide, I invite you to ask the question. I think between myself, the other people in here with a lot of credentials, we can try to answer that question. So this isn't meant to be a lecture. It's supposed to be a little bit interactive, and if you see something, let me know. But kind of our starting point is, first, where do we get the authority to zone? And that is particularly as a non-home rule municipality, which means we haven't reached 25,000 people. We have not voted for home rule status in a referendum. Hence, we're left with non-home rule. And that means a couple of things. First, the Illinois Municipal Code is made up of several sections, and that's what provides our statutory authority to zone property. And what it means is this is, in the words of Judge Dillon, who was a Supreme Court justice on the Iowa Supreme Court, is if you're a non-home rule municipality, you have to look for either explicit authority for you to do something, or is there some sort of implied inference that from the statute, this is what you can also do. And this is much different than if you were home rule. Home rule, you can do anything you want so long as you don't run afoul of certain guidelines, such as the Constitution, not violating one's due process, things of that nature. And did I go too far? This is Bob Dillon. That is not supposed to be Judge Dillon from the Supreme Court, but here's what Bob Dillon stands for as it pertains to our discussion tonight is when someone says, you know, we don't want to be swept in by any borders, no fences. That's not the case. You can't be Bob Dillon. You can't be Evel Knievel. When you're looking for authority, particularly in the zoning context, you have to look to that Illinois Municipal Code. Home rule municipalities have a lot more authority. And we talked about a couple of the restrictions on home rule, but you can also run afoul in terms of even home rule municipalities are bound by this dictate in the Illinois Constitution, and that is your powers as a home rule municipality are limited to your government and affairs. And that's why you'll read once in a while, there may be a fight. And there are various instances in which the city of Evanston, as a home rule municipality, would get into a fight with another body of local government, such as a regional sanitary sewer entity. You know, they would want to locate facilities in the city of Evanston. They don't want those facilities, and who wins? And generally, if it's just a question of whose authority trumps the other, usually that regional body will even trump the home rule municipality. So that's our starting point. So again, whatever authority we have, including zoning, it's sort of a mother may I approach. Is there something in the statute which allows us to do what we want to accomplish? So what the Illinois Municipal Code provides is that if you want to implement, if you want to exercise your zoning authority, you start with either a comprehensive zoning ordinance or, as the case may be, an amendment, which is done from time to time. And by that comprehensive amendment, that's where a municipality, if it's ambitious enough, takes its entire code. And what it may want to do is make changes throughout the code. The first section, the second section, they may want to take text amendments and they want to make changes to some of the uses in business or commercial or residential. This is where you put forth what's sometimes called bulk standards. And by that, what I mean it to understand is the very hard black and white aspects of putting a building on a parcel, such as the minimum acreage. How far does it have to be from the front property line? How far does it have to be from the rear and side lot lines? Very black and white. In conjunction with that, the municipality usually adopts also a zoning map, dividing the village or the city into districts, and even specifying that for each parcel in that village or city, here is the zoning associated with that particular parcel. And if you think of it, if you've seen a zoning map, it almost looks like a paint by numbers painting, where here's the parcel and you can trace it to the legend, here's what zoning district it is. So with respect to a comprehensive zoning ordinance or amendment, technically, if you read the statute, you're only supposed to have to publish it, notice of it in the paper, one time. That was a change in a couple of years ago in which what happened was the appellate court for the first district, which is Cook County, maintained that when the city of Zion went about its comprehensive zoning amendment saying we're making all these changes, one of those changes particularly affected apartment owners. And what the situation was in Zion was, if before the comprehensive zoning amendment, that apartment owner could put up, say, for example, 90 apartment units within a building on a parcel, under the new comprehensive zoning amendment, it was reduced. Sometimes that's referred to as down zoning, a less attractive zoning district, from 90 units to, say, 30 units. And what they said in that instance is this was, even though the statute only says that notice of that comprehensive zoning amendment has to be published in the paper, to the extent that comprehensive zoning amendment impacts a particular group of owners adversely, you should give them individual notice. And in between, reading between the lines of this case was, the court didn't appreciate the fact that what the city was trying to do was kind of sneak in restrictions on someone's rights that they had before. On a given Monday, they could put up 90 units. A week from Monday, they could only put in 30 after the zoning comprehensive amendment was adopted. They don't like that. They want to see fair play. They want to see notice. And so, for example, even when we do a text amendment, what our practice is if we think there's one particular group that's going to be adversely affected by that change, we try to mail notice to them in addition to the usual publication in the paper. How is that comprehensive zoning amendment or map, how is it changed? Well, it can be done in a couple of ways. First, anyone on a given property can petition the village. It's a First Amendment right. You have the right to petition the government for what the federal constitution calls redress. That is, you can ask the government anything, so to speak. And what you can ask for is a change in the text of the zoning ordinance. For example, I want another permitted use within my district. Or two, there may not be an issue with the text in the zoning ordinance. They can say, I want to rezone my property. Rezoning the property is typically referred to as a map. You're changing the zoning map. It's a zoning map amendment as compared to a text amendment where someone says, I want to add something. I want to add a permitted use. I want to add a conditional use. I guess theoretically someone could ask to remove text in a zoning ordinance, but we don't see that very often. So the fundamental rule that the village staff has to wrestle with respect to preparing a zoning ordinance or an ordinance of any kind is that ordinance is supposed to be objective, precise, as clear as possible so that someone knows what their rights are. And here's where the difficulty is. The courts want you to be able to, someone is able to pick up a book and see what their rights are with respect to their property. And some municipalities have gone so far, concerned about aesthetics, that they'll try to put in place an architectural review commission. They'll write that into the ordinance and say, this is what we'd like your house or commercial building, as the case may be, to look like. And the problem is this, the problem with these architectural review ordinances is that by definition, they're subjective. They're not precise, they're not objective. They usually use terms like buildings must be in compatibility with other buildings in the neighborhood. Houses must be in harmony with another. It's difficult to define what is in harmony, what is compatibility. And so I think at this point, there's been 2 court decisions which have looked at municipalities who have put together these architectural review ordinances and determined them to be invalid because of that subjectivity. The other thing with these architectural review ordinances, because the village or the city council doesn't want to deal with it, they'll delegate those ordinances, the implementation of them, to the zoning board. They don't want to get into the architectural details. They say, we'll want the zoning board or the planning and zoning commission to do that. And the second reason the architectural review ordinances are deemed to be invalid is because courts don't allow that kind of delegation. What they say is the bottom, the buck stops with the village board or the city council. Generally speaking, unless you specify otherwise, that zoning commission is supposed to be a recommending body with certain exceptions. So the second reason these are taken down is they don't want these village boards delegating that authority to the planning and zoning commission. Before we leave this area, let me talk about people who will claim that they have a vested right. So for example, say that the village comes to the realization that there's a permitted use in a district that they don't find very appealing or they think is outdated. They just don't feel it's compatible with the rest of the neighborhood or the rest of the buildings in that zoning district. The village itself can petition to change the zoning in the text amendment or with respect to the zoning map. It's not done very routinely, but do you have that authority? Yes. So if someone ever sees something that says, I don't think this belongs in here, I don't think that's appropriate, can the village go about petitioning to change that? Yes, provided it sends out notice that there's a hearing on that text amendment, as the case may be. And what you'll often hear is there's almost like a knee-jerk reaction. Well, that's my property right. I'm entitled to it. People who have read a couple of cases on this may even say, I have a vested right to that permitted use that's in that district. And that's not the case. What the Illinois courts have said is, you don't have a vested right that just because a permitted use is in that zoning district, in that text, you don't have the right for it to be perpetually in there. It is, at the end of the day, legislation. And what the courts say is legislation can change. You can modify it. Just because you have something in your zoning ordinance in 1951 that, maybe someone can have a tannery or something like that, an animal rendering plant, that may not be the case in 1985 or 2025. So in order for someone to have a vested right in a permitted use, what the courts usually require are at least a couple of things. That one, that an expenditure of money be spent in reliance on that use. So say, for example, someone says, I want to do a food manufacturing plant in a given district. And the village becomes aware of it. It feels that there's a question as to whether that's appropriate. And it goes about going through notice and a public hearing to remove that from the books. The person usually can't claim to have a vested right because A, they haven't spent a ton of money on that. They have to spend money on architectural plans. They have to say, listen, the building was going to cost $5 million that we wanted to put in. We spent $1 million in reliance on this. And the courts actually are very tough and very scrutinizing when someone claims, I have spent money in reliance on it. For example, Illinois appellate courts have said, if you knew there was a change, a potential change in that zoning, and you spent money afterward on that use, you don't get credit for that. You didn't do it in reliance on that because you were put on notice that the village was considering a zoning change. So, for example, let's take a different situation on the other side of the coin where someone goes about building something in their backyard based on a building permit. The village takes action at some point to remove that potential use. If that person spent money, if they, pursuant to a building permit, built something, even though there was this process that was going to remove that potential use, those people have a vested right. We spent money on it, we built it, we thought we could rely on the building permit. You can't revoke that at the end and have us take us down. So are there any questions about that with respect to the vested rights issue? Okay. Let's go on to for a moment about objections and where the village may get involved in one within the village and then also outside of the village in an unincorporated area. So what the Illinois Municipal Code provides, as does our ordinance, is that in the event that there's a zoning map change being requested, or even a text amendment. If 20% of the people whose property fronts the property that's in question asks, we are filing an objection, we do not like the zoning map amendment, what it requires is, at least in the village here, that if that's properly done, and there's usually a question as to whether that was done properly because not everyone's property has something that says, here's our linear footage. They also want to see that the petition's notarized, you know, and that someone's not signing for their neighbor or someone's not signing for somebody else. But that usually requires here in the village a 2/3 vote of the then sitting trustees in order to pass that zoning map amendment. It doesn't usually make a difference to us because you need 4 trustees to pass something anyway, ordinarily. But here's where this becomes a little bit more interesting is the village may be called upon to vote that to the extent that there is a conditional use being requested in an unincorporated area that someone doesn't like, and the residents come here saying, listen, although it's in an unincorporated area, maybe there's a potential use, a type of conditional or special use that we'll talk about later. We don't like it. It's going to have an adverse impact on us. We want the village to file an objection, not the 20% frontage, but just the village itself file an objection with the county. And that's where it triggers a 3/4 vote of the county board members. And there have been quite a number of conditional or special uses that have been turned down by the county because while that landowner may have been able to secure a majority vote on that county board, not all of them are willing to get to a higher threshold of 3/4 vote. So you may have a situation in which residents approach the village to say, object to what's going on in the county. And if done correctly, there's a procedure. You have to give notice to the landowner's attorney. You have to file it with the village clerk. It has to be passed by the village board. That can trigger a supermajority vote, which results in that requested use being turned down. Certain townships also have that right to file an objection if they set up their own planning and zoning commission. Any questions about that? No. So in the situation, like say that, say someone objects to a dog food plant being located just outside the village. In that situation, if the village board chooses, the village board can take action to file something with the county clerk without having to get a certain number of people signed up. The village can simply file an objection, and that requires a supermajority vote. In addition to the village just being able to do that, people, if they share frontage with that dog food plant, can file that 20% objection and also require that supermajority vote. So there's a different couple of paths of getting to that supermajority vote requirement. So where does the comprehensive plan? So where does it fit into all of this? The comprehensive plan is supposed to be a very broad brush vision of what the village wants to see as part of its development. And if you think of ours, what it tries to do is to say, here's where we want the residential. Here's where we want the industrial. Here's where we want to enhance our downtown. Here's where we think is an appropriate places for churches. For example, one municipality in its comprehensive plan said, we don't want so much traffic going through neighborhoods, going to church, temple, whatever. And instead, we want churches to be located on state highways to better handle the traffic. At least that was the justification. And it's also meant to address more controversial uses. You know, in addition to church with maybe a high traffic count, it's supposed to address issues that are more controversial, such as if there's gravel in the village, where do those gravel pits go? If there's going to be a water tower, if there's going to be a municipal water or sewer treatment plant, where is that supposed to be located in the future? And the purpose of that is twofold. By telling people in the comprehensive plan where these uses, they might be more controversial, are going to be located, it helps the village in 2 respects. When someone comes to the village board and says, I moved in, I bought a house, and now I find out that the village is putting in a water treatment plant right next to me, and I don't want that, or a sewage treatment plant, as the case may be. The village can point to the comprehensive plan and say, listen, going back to 2004 when we first implemented it, this was the plan. This was supposed to be here. The fact that you may have moved in, you can do that. You can move in next to it, but here's the plan that provides this was the use that we're going to put in a railroad station. Alternatively, if that person goes so far as to say, I'm going to challenge the village. I don't want that railroad station next to me. It wasn't here when I moved in. I don't want that sewage treatment plant. I don't want the water treatment plant. The comprehensive plan is often the second or third factor that's looked at by a court in terms of justifying a zoning decision. Is a comprehensive plan legally binding? Is it legislation? No, it's supposed to be advisory. With the broad brush strokes, this is our vision. This is what we'd like to see. This is how we want the town to develop. But the courts are very much into what did the village plan? And so one of the justifications to help with a zoning decision to say, we have the sewage treatment plant there, that's why we think it's appropriate, or as the case may be, a church or something else that may draw someone's ire. If the comprehensive plan shows that the village or the community planned for this, the better the chances it's going to be upheld. And the reason this is important is the better done it is, the more likely it's going to earn the respect of the court if there's a challenge. A few years ago, the county of DeKalb won a case. Someone wanted to put in a subdivision in and amongst the farms outside the city of DeKalb. And the reason the county of DeKalb won when they turned down the zoning for a residential subdivision was the court took the time to point out that the county of DeKalb plan did not anticipate residential in that area at the time. And two, it was an award-winning plan. It had been submitted, it got some awards. That carried the day. And the thing is, because zoning is so difficult to figure in terms of what a court is going to do, I mean, at the end of the day, a judge, he or she, it's not software, it's not a formula. I think that frankly, it's very subjective what that court, what that human judge is going to say, that to the extent that you have a comprehensive plan that's well done, that supports your objectives, that reinforces your zoning decisions, that is a big deal to winning in court. While a judge is supposed to be able to say, if it's reasonably debatable as to the decision that the village or city made, that court is supposed to defer to that village or city decision. To the extent that you have a plan that says this supports the zoning decision, that's helpful. So let me leave that for a moment and talk about subdivision regulations. We don't talk a lot about that. The subdivision regulations are the direct opposite of the comprehensive plan. Whereas the comprehensive plan, you got broad strokes, here's our vision, here's what we see, just in kind of the big picture approach. Subdivision regulations are the direct opposite. It is very hard and fast, black and white. And what those subdivision regulations point out is the road in a residential subdivision shall be 5 inches in asphalt surface. It shall be beneath that 10 inches of stone. It's very hard and fast. It's calculus. Here are the requirements. Here's what you must do for drainage. If you don't have concrete curb, you shall have drainage that releases at this rate. It's very specific. It's very hard and fast. We don't deal with this very often, but if you have a comprehensive plan that you've adopted that shows even how you want to see the area outside the village develop in the future, as far as 1.5 miles away, the only time you reduce the 1.5 miles is if there's a village that's closer than 3 miles. At that point, it's the equidistant point. It's not 1.5 miles. So say there's another village that's 2 miles away from us. In that case, our comprehensive plan would extend only 1 mile. But here's what people don't usually understand is your subdivision regulations actually apply to that outside area. So if someone wants to develop a subdivision outside the village, it's our subdivision regulations that can control the drainage, streets, the infrastructure. And the idea is this. I think that when the Illinois legislature imposed what they call the extraterritorial jurisdiction of the village to impose the subdivision regulations, the legislature took into account, I think most likely, that a lot of these subdivisions end up annexing to the village, even if they were platted within the county. They may experience problems with whatever, drainage, roads, whatever. And so I think the experience I've had is these subdivisions approach the village to say, can we join you? Can you provide village services? Can you help us with our roads and drainage? Here's the conflict and here's the issue. If you actually look at the statutory authority for a village to have subdivision regulations outside its municipality, it talks about minimum acreage requirements. People usually think of minimum acreage requirements as zoning, not a subdivision authority or power. And the controversy that has come up from time to time that hasn't been decided by a court yet is whose acreage requirements will prevail. So if you can imagine, the litigation I had was a village, which was very equestrian, very rural in nature, objecting to a plat of subdivision outside its boundaries with smaller lots than what it would have preferred. It met the county zoning acreage requirements, but not the villages, which were higher. And the reason I didn't get a decision on it was the village won the case for other reasons. And the court never addressed this acreage requirement, just saying, listen, the plat's going to be held to be invalid for other technical reasons. I don't want to get into this. I don't have to decide that. Just the plat's invalid. So there's never been an answer on that. And if you actually look at the zoning authority of counties, it doesn't say minimum acreage requirement. It talks about area. And so the question that remains unanswered is, in a fight over a subdivision outside your boundaries, whether it's the minimum acreage in a subdivision ordinance or the minimum acreage in a zoning ordinance, which one would prevail if there's a conflict? We don't have an answer to that. Let's talk about variances for a second. And by definition, a variance is simply this. It is seeking relief from a village or a city to use your property in a way that's prohibited by the zoning ordinance. And that's why, because you're asking for this extraordinary relief, where you're asking for something that's completely forbidden by your ordinance, what the Illinois legislature said in the statute regarding variances is you must be able to demonstrate, if you're a property owner, practical difficulties, particular hardships. And here's what they want to see, here's what they don't want to see. And I'll give you two examples. The courts, the Illinois legislature, when they created the statute, want to see something that is unique to that property, that is so different from everyone else, that it justifies the relief, the suspension of a zoning requirement that otherwise would be applicable. So let me give you an example is, I guess that the legislature, the courts would be okay with a situation in which a homeowner approaches the village and says, I want to build more into my side yard setback. I want to be able to add on to my home because I have a unique situation with my property. I have a practical difficulty. There's a wetland that's in the back of my property. And if I wanted to, even if I wanted to, I couldn't build my house back there. Normally, I would have more space into the backyard, but it's this wetland. It came with the property. I can't build into it. Maybe it's protected by a U.S. Army Corps, but physically it's an obstacle. That's what makes this property so unique. There's a lot more sympathy for that situation than someone on the same parcel, but instead of the wetland being there, created a pond. I like a koi pond. Built a pond in the backyard, took up all this space where ordinarily a home could be built, within the setback lines of the rear yard, the side yard. And the courts don't have a lot of tolerance for that if someone challenges it. So they don't want a situation where the person's asking for a variance because the hardship, the difficulty was self-made. They don't want you to create something. They don't want villages to hand out variances because it helps with someone's convenience. It's supposed to be unique. Now, I'll also say that it's not supposed to be based on personal circumstances. So there was a case from Highland Park years ago where the woman maintained to the zoning commission, I want the variance to be able to build out further into the side yard setback with my home because with my leg problem, I have difficulty going upstairs. I don't want to go to the second level. I've got difficulty with mobility. I want to be able to go on the main floor that way. And when the village turned her down, I guess it's a city of Highland Park turned her down, the appellate court agreed, saying this variance, because it runs with the property, it's supposed to be based on the property, not your personal circumstances. When the village or city, as the case may be, turns down that variance, we agree with that. Now, the only change that's developing that's making this more complicated is despite that Illinois case law saying you can't base it on the person, the person might not be there in 20 years, is there are more and more issues are coming up with the Fair Housing Act and emotional support animals. And I think that's tricky because it's comprehensive. Courts, I should say this, the federal courts tend to be very, very sympathetic that if you have someone in the home, these cases almost always involve a child, some difficulties, emotional difficulties, physical difficulties. They're very sympathetic to allowing that support or emotional support animal in that house. There's not a ton of cases on it, but a typical case will be this, where a child has such physical disabilities that a mini horse in the backyard that allows the child to exercise, that allows the child to stand by leaning against the horse because they have such difficulty. Courts are very open to that, especially the federal ones, they're removed. The judge who makes that order saying, yes, I'm going to let the mini horse in your backyard probably doesn't shop in your local grocery store. He or she is located up in Rockford. So it's not like there's a lot of concern about the community. It comes up with other situations too. There was a case that came up in Michigan. And I think it was kind of a cynical approach as to what was taken. So the person who wanted chickens on his property that were otherwise prohibited first maintained that the Michigan Right to Farm Act applied to him and said, I want to be able to raise chickens under this statute. It was otherwise a residential area. When it was pointed out by the court that that wasn't applicable to him because he was within, I think, 150 feet of a residence, so the statute didn't apply, he took a different approach and said, I need these chickens in order not to be depressed, to lessen my anxiety. And I think in that case, he needed several chickens. And he went from this approach of saying, I want to be self-sustaining, I want the ability to farm, to, I think, a little bit of a cynical change to say, okay, now it's not so much about the right to farm. I'm suffering from anxiety. I have emotional issues. The court was open to it. And the point is that this litigation in court is expensive. And what the city up in Michigan eventually did was they threw up their hands and said, listen, at this point, we've done our best. They did not want to go to a jury trial because in certain circumstances, if you run afoul of federal law, you're at the risk for attorney's fees. So it's not that someone's property is going to be damaged necessarily, but municipalities are very concerned about violating federal law and paying the resulting attorney's fees, whatever they may be. And at that point, it may be 50, it may be $150,000 or more. Before I leave variances, and we'll talk more about this, with any variance, you're supposed to have findings of fact that's set forth in the statute. And what the findings of fact is a very specific finding as to why this variance is necessary or appropriate. And the reason that we, the staff, work so hard on these variances to the extent there's a finding of fact is we want to be able to justify it, one, that we did the right thing, but two, this is the village's opportunity to explain this is why this is unique. This is why it's deserved. And here's specifically what's going on so that there's less chance of someone else in the future saying, well, you granted a variance over there, give it to me. These findings of fact are what allow us to say, no, this doesn't set a precedent. There was a unique situation, and they're supposed to be very specific. It's not just supposed to be, Yeah, we think there's practical difficulties. We think there's particular hardships. It's not supposed to be generalized. It's supposed to be very specific. And absolutely, by statute. Yes. Yeah, and I think that the difficulty is this, is for the Planning and Zoning Commission is when the neighbors don't show up and you don't know what that means. And by that, I mean, is it because the neighbors are too afraid to speak up? Or does it mean that they're accepting of the variance? It's a tough call. But what the courts also say is just because the neighbors don't show up is not a justification for the variance. And that's usually the first thing you hear out of somebody like, hey, no one showed up, so give it to me. In theory, that's not supposed to take place. Might it take place in real life? Yes.
You appeal that decision that we make as an individual. And it can have, the cost for variance. Whoever it is, they deny it. You appeal that, you hire it up.
Yeah. So let's talk about that. So they come before you, the Planning and Zoning Commission, and I say, I want to put the side yard setback is 15 feet. I want to increase my garage into the side yard lot line, and I want that minimum setback instead of 15 feet, I want it to be 5 feet. So my first opportunity is to come before this Planning and Zoning Commission and to request the relief, and you're going to make a recommendation. You're going to make a recommendation to the village board in favor or against the variance. So to answer your question, that person, say that the Planning and Zoning Commission recommends no. They don't want it. Their appeal, so to speak, initially is to go to the Board of Trustees and say, I want a final decision. And this is why I think the Planning and Zoning Commission is wrong. They didn't take into account A, B, or C. From that point, say that the Board of Trustees says, no, this is why we have a Planning and Zoning Commission. This is the front line. You're supposed to scrutinize this. You get this experience. That person's recourse is they have 90 days, and that was changed. They have 90 days to appeal that decision by the Board of Trustees to a circuit court. It used to be longer. And the reason it got changed from it used to be up to 5 years' time to 90 days was that people would be objecting to zoning items such as a grocery store, a Meijer, a Dominick's, a Julasco, and they would wait. Instead of bringing that court action right away, they would wait and then bring the suit a year later, a year and a half later, which really screws up the process because they're in the middle of building something. And usually my experience is that if someone challenges a zoning decision in court, once that happens, the bank or the lender turns off the funding for that loan. They don't want to be putting money into something that may be overturned. And so that's why the courts turned down and said it's no longer a 5-year time frame to challenge a decision. It's now 90 days. So we talked about, just before I leave this is just in general, this isn't with respect to variances, but when you make a motion, this is a very plain spoken commission, but what you want to avoid is motions that are negative. It confuses people. I vote to deny this because what I usually suggest is trying to make it in the affirmative and say, instead of saying I motion to deny, I motion to turn down this plat. Don't put this in a double negative. Do it in a way that it's plain spoken. Don't worry about legalese. And in fact, if there's ever any trouble, the staff here bends over backward to try to provide that language. Now, you can always modify that language to add conditions, restrictions, or whatnot, but try not to use double negatives in those motions. Just as a matter, especially when it gets to be 10 o'clock at night, there's a lot of people in the room. You just want to be plain spoken so that everyone knows what they're voting on. Yeah.
The HOAs play into all this. I don't know how many different HOAs you have in town, but say somebody wants to make a variance on the fence, don't they usually go to the HOA first?
Great question. Great question that we have faced before. So here's the thing. Let me speed up a little bit. No. So here's how we deal with that is, first of all, right here. So first of all, covenants by definition are separate, independent from the village zoning ordinance. Covenants are nothing more than kind of an old Englishy term for a private contract among landowners that say, this is how we're going to restrict the use of the property. Is it enforceable? Yeah. Again, if it's something that's specific, it's precise. But let's take your example. We have all these HOAs, and someone says, I want a variance. So my HOA says, I can't have a fence in excess of 6 feet. Normally, what they'll do is, but they may not, they go to the HOA first. If you're responsible, you want to try to do the right thing. You ask that HOA for a variance. My position is that, say they don't get the variance and they go to the village and say, village, I want a 7-foot tall fence. Say that our village permits it. I'm not sure that's the case, but let's just go with it in this example. Our opinion is that if this is our ordinance and that ordinance allows a 7-foot fence, we have to allow it. And because we're not guided by private covenants, that's not our contract. We don't enforce that. I think that to the extent that someone comes to us and says, I want that 7-foot fence, what the village is trying to do is to hand out a building permit that says, okay, here's your building permit for a 7-foot fence, but that doesn't relieve you of any obligation you may have under the covenants to comply with those. So the risk is to that person, someone may choose, they may not, because it's expensive to litigate, that homeowners association, a neighboring owner typically, is empowered to enforce that covenant and say, take down that fence. So, and here's where I'm leery is from time to time, and this is kind of a tough decision for municipalities, is when we have the benefit of an annexation agreement, some municipalities will say, put in place a set of covenants. It's perceived to make the development more higher class, no dry cleaning in the backyard, things of that nature. But there's inevitably a tendency for the people in that homeowners association that when someone's not complying with it, to come to the village and say, can you enforce these? And the reason being that the individual landowner doesn't want to bring suit to enforce the covenants. That's money, that's a lawyer. The HOA may not have any interest. And it's kind of like that scene in Braveheart. So William Wallace defeats the English army. They retire to the Scottish castle. And as soon as Mel Gibson goes into the castle, people are coming up to him saying, listen, here's my contract with that guy over there. Enforce this. And he's like, no, I don't want anything to do with this. And the problem is with these covenants, the downside that I see is that they're fine. They're probably very well done, probably by a competent attorney. But the problem is that very often village staff, the village board is being asked to serve as kind of an attorney general to enforce those. And the thing is, should we be doing that? Probably not. If it's a matter of public importance, but this is our ordinance, this is what goes by. Should we be in the business of enforcing those? Probably not. And then two, as a practical matter, even if you think something's straightforward in the covenant, these documents are sometimes 60 pages, single spaced. I've litigated them. They'll take 3 years. People can draw this out. And, I've had good luck with enforcing these, but it takes time, it takes motivated people. So does that answer your question?
Yeah, kind of sticky.
It is sticky. And the thing is, the question for the village is, do we want to enforce someone's private contract, even if we're empowered to do so, when it's not part of our ordinance?
If HOA has restrictions or guidelines, building things, can we overrule why the village?
In a sense, yes. So let's go. It could be contrary to the village ordinance. So first of all, there's certain limits. you can't put, as of 1968, the Supreme Court said you can't put racial covenants in these things. You can't put racial restrictions, and there still are. You'll see them. But if someone wants to say, we want no Irish in this neighborhood, not enforceable. Along the same lines. But here's the thing. Someone could, if that restrictive covenant is more restrictive than a village ordinance, that can be enforced. Like, for example, in some of the nicer neighborhoods, you may have an architectural review commission. And if it's done appropriately, a court will uphold that. Whereas a village could never get away with that. If you went to someone and said, listen, I'm a big fan. I'll tell you this, two of my biggest heroes in life, Prince, Jimi Hendrix. I want my house purple. That's all I'm about. I'm a purple guy. That architectural review commission may say, no, we don't want purple in our neighborhood. And you have to get our permission in order to go forward with that. You would never be able to stand in court if you're a village to say, we don't like purple. Not appropriate. Is the covenant in that instance more restrictive than the village ordinance? Absolutely. And that's why I think that, the one annexation agreement that I've worked on with the village, the architectural review that we've done is we try to restrict it to none of the similar models across the street or next to each other. We try to keep it objective. We try not to get into the color schemes and things of that nature because it's more subjective.
And that also mentions it's a practice matter. And part of like the building permit costs. When someone comes in for a building permit, the village has written into our code that most of those permits, we want to see certification of the HOA, and the HOA is prohibited. That's something that we decided to do and work with the HOAs over time. To Michael's point, most of the time, the HOA rules are more strict. Not all the time, but most of the time they are more strict. So the standard's going to be higher for the HOA. So that's some background. But we voluntarily write in the HOA part of some of our building.
So tell me this, Andy, what would the village do if the HOA said, we didn't give permission, say it's authorized by our ordinance, but not by the covenant? How would the village treat that?
If it was authorized by the ordinance, not covenant.
Correct.
It would depend on the specific
Okay.
instance, but for example, let's take a fence or something. Our fence code says part of the building permit approval is a letter of approval from the HOA.
Mhm.
So if they didn't make it past the HOA, but that's something we chose. In theory, if say something comes up that it's not in our village code or it's not come up before in practice, if it meets our standard but doesn't meet the HOA standard, then we would say you gotta go to the HOA. It's okay, but you might have problems with the HOA fines or whatever they do.
Our relationship with the HOAs are kind of a one-on-one, meaning as it comes up, you don't continually work together on broad issues.
Not typically. I mean, we as things come up, we talk about it. Every once in a while, if we're gonna update people, we'll coordinate with them. But in general, the rules of the HOA are laid out in those covenants, and those don't change. And our village rules, they change over time, but they don't change, very regularly.
Okay, so let's move on to what are called special or conditional use permits. And by that, I mean this, and that is, as I use the term, special means this, that it's not a permitted use as of right. You have to have a public hearing, to Jack's point, before the Planning and Zoning Commission to ask for it. It's also sometimes referred to as a conditional use because what the statute provides that the municipality can do is, if it's considered to be a special use, unlike a rezoning, you can put in place reasonable conditions to alleviate the impact on neighbors. And so typical special uses or conditional uses are things of such a nature as a gravel pit, a church to the extent that you've got bell ringing, you've got massive crowds coming in on Sunday at 9, 10, 11 o'clock, a bar coming into a neighborhood, that stays open a little bit later, it might be a little bit louder. And what you're supposed to be allowed to do is, as a municipality, again, to the extent that it's reasonable, to impose conditions with that. If we're going to have a church, here's what the conditions are with traffic. Maybe we want screening, things of that nature. What changed in 2008 was this. There was a case that was called City of Chicago Heights versus Living Word. And what that case stood for was this, that to the extent that a city or a village listed a special or conditional use in a zoning district, say that we allow churches in the commercial district, that is, in the words of the court, a legislative finding that if that church meets the criteria that you set out for a church in that district, they get it. So I used to go to zoning commissions many years ago, and I remember the chairman in a different municipality saying, hey, this is a special use or conditional use permit, so we have total discretion to turn it down. Not the case from at least 2008 on, because the finding in that case, this City of Chicago Heights versus Living Word, was a church wanted to locate on this key commercial corridor in Chicago Heights, and Chicago Heights turned it down. They said, no, we don't want a church in this commercial corridor. It has nothing to do with religious beliefs or anything like that. We're not discriminating. There was no suggestion they were discriminating. We just want the sales tax. We don't want that taken up by a church. But what the Supreme Court said was, well, then this, you shouldn't have listed it as a conditional or a special use in that commercial district. Once you do that, again, if they meet the criteria, they get it. So it's not as if you have total discretion that if something's a special or conditional use, we can just turn it down at that time. No, once you put that on the books, you have to adhere to that. You have to grant it if they meet that criteria. And that was a big change. The Supreme Court felt it was necessary to make that decision. And again, you can put reasonable conditions on it, but be careful with this. So the example that I had was years ago, the Village of Oak Brook put in place on one of its special use ordinances a requirement that to the extent that the special use adversely impacted property of homeowners, that the landowner would have to indemnify them for any loss. Do I think that's reasonable? I think that's questionable. We don't go around the town saying if a gas station, if a restaurant, a bar that goes on for too long has an impact on values, they have to indemnify the person for any loss. Is that something that I think is questionable that would not have prevailed if it went up to the court to be examined? Probably not. And again, just like a variance, you have to have findings of fact because you're allowing something that may have an adverse impact on neighbors. The idea is that kind of like a variance where you're going against something that's required by your ordinance along the same line, they want findings of fact. What is a planned development? A planned development is a type of a special use in which I think there's two alternative ways of using this, and that is the first situation is if it's a planned development request and your ordinance allows it, you can suspend your zoning requirements to save some special feature on the property. So say, for example, a landowner comes to us and says, I have 10 acres, but in the middle of this property is a beautiful stand of oak trees. And while I'm normally only allowed to develop one house per acre, I have 10 acres. What I'd like to do is this. I'd like to have 10 houses, but don't make me adhere to that minimum 1 acre requirement. Let me put in the 10 houses on the 10 acres. Let me preserve that stand of oak trees in the middle and give me a higher density. That in this case, each lot is going to be 9/10 of an acre because we're going to try to save that future of oak stands. That's the idea of the planned development. The planned development gets into trouble, it's a bad name, where it's used as a basis by a developer to just increase the density as a pretense to say, we're going to save some feature, I just want more houses. The second type of planned development is where you have different even zoning districts. You may have different zoning uses all integrated together. And one example of a planned development, Disney World. Think of it this way. You've got your one area for amusements, you have a separate area for restaurants, you got a separate area for the hotels, you got a separate area for the pools, you have beaches, and all linked by a monorail, this transportation system. That's probably the best example where you get different uses, but the reason it's a planned development is it all works together. There may be different zoning districts, there may be different types of uses, there may be transportation hubs, but as a whole, it fits together. On one hand, it gives flexibility to the developer. Again, if the ordinance allows for it, you can deviate, you can give relief on your zoning requirements, but in exchange, you're supposed to be getting a better product. You're supposed to be able to see we're saving some special feature of the land. Or two, while there is flexibility to the developer, you're getting a picture, or you're supposed to, of what the development's supposed to look like. Here's the plan with the footprints of all the buildings. Here's the layout. Supplemented by, here's a landscaping plan, here's architectural review plans, and it's all going to go into the ordinance. And is it thought of as a contract? Maybe. So while no Illinois court has said this, a Wisconsin federal court has said a plan development is a type of contract between the village and the developer. That developer is putting forward, here's the picture of what I want, approve it, and from the benefit of the village, they know that the 2 or 3 uses that may be going in there, here's how they're linked together. Here's the approach transportation system, or as the case may be, here's how the parking lot's going to flow, and it works. This is what we want to see. This is the detail. And to the extent the developer wants to do something else, to say, if you wish, developer, we want you to come back. If you want to amend this type of contract, come back and show us the plans. So before we leave this, any questions about that?
One thing I'll mention too, with planned unit developments, this has been, the village has typically used this approach in the past and well, in the future. It's actually something we were talking about, this body here. It's not only about specific developments, but about changes to our code related to planned unit developments. We think that the advantage of the planned unit development is one, from the land use planning perspective, it can provide greater flexibility to use the land in a way that meets the developer, but also the village, instead of having to adhere by the book definition of rules on every single item. And then secondly, we think it's good because it gives the village, both planning, zoning commission, and staff, the village board ultimately, more oversight and involvement in the process. Now, it's, as Michael mentioned earlier, oversight and involvement doesn't mean we get to say absolutely yes, absolutely no, but having something developed in that manner, planning development, does give the village board the ability to review and comment and negotiate, and provide feedback on it. So I want to point out, that's a big important thing about what we are, what we do and have done in our.
Here's the additional detail in my plan that you don't get with a straightforward rezoning. There's not really authority in Illinois law that if there's a simple rezoning from C to residential or vice versa to say, here's the conditions we can impose. With that plan development, you get the detail and less surprise. So just real quickly on the findings of fact, what the courts say is, listen, we just don't want you to parrot the language. We don't want you to say, oh, there's a particular hardship, there's something unique here, and here you go. Here's your reduced side yard setback. And the courts, if they're aware of this issue, take it seriously to the extent that years ago, a colleague of mine represented an adjacent landowner in the village of Cary. Village of Cary had no findings of fact. Once it was pointed out, it invalidated the ordinance. Is there a second chance? Yes. In the event that, say, for example, Planning and Zoning Commission turns down a request, doesn't do findings request, they just say, we turn it down, we don't like it, we're not going to recommend it. Can findings of fact be made by the Board of Trustees? Yes. And they can be incorporated into the ordinance. But this is just something technical that this is what the staff tries to be conscientious about because, as you can imagine, if we think something's beneficial for the village, we don't want someone challenging it and holding it up or thwarting it for a year and a half as it goes to the court if we think that's something beneficial to the village. Something that causes a lot of confusion is the term non-conforming use. And here's how I understand the term, and that is a non-conforming use is a legal way of saying it's just not permitted. It's not a permitted use. It's not a special use. It's not a conditional use. So basically what you're saying is that whatever the property is being used for was never given a building permit by, as the case may be, say it was Kane County. So say that the village annexed a property from Kane County. It was unincorporated. It's being used for a given purpose. People will try to attach a lot of terms to that. They'll say, well, it was grandfathered. It's been there. It's an established use. There's a precedent. It's all meaningless. The question is, and what's not helpful to that analysis is this. The question is this, is when that building was established with a given use, was that appropriate under the zoning ordinance of the relevant zoning authority? So if it's something that's unincorporated, the question is typically, was that given a building permit? Was that permitted by King County? It's the same analysis with something within the village, and that is, was that an appropriate use when it was first established? Was it permitted? It's a different situation. So say that we allow chicken manufacturing facility in 1950. Subsequently, 1960, the village takes out the reference to chicken processing facility. That doesn't make it illegal. What it's called is a legal non-conforming use. It's no longer permitted. So if I wanted to introduce a new chicken processing facility, I couldn't do that. But if it's established and that was appropriate, it was completely kosher at the time that went in, that's fine. It can continue. And Illinois law says you're supposed to allow that continue unless you do something like you phase it out over time. And when I say phasing out, they'll call it amortization. And courts are not real big on having someone's building shut down, say, after 5 years when that permitted use is removed. No, the context that I've seen municipalities try to phase out something are signs. And even that's difficult. Even when you say your sign is non-conforming, you have to take it down in 5 years. Or in the case of the city of Harvard, Illinois, city of Harvard says, we want driveways to be paved. We don't want them to be gravel, and you have to pave it over in 2 years. It's difficult because, leaving aside the legalities for a moment, people don't want to do that. People get aggravated and people get very upset about this. And the question is usually, even if you put this on the books, before you do that, before you say, hey, this is an excellent idea, let's remove these signs after 5 years, the question that should be incorporated as part of the analysis is whether the village or the city is going to have the will to enforce that 5 years from now. People just don't appreciate the fact that they have a sign, it was there, and somehow the village or the city wants to take it down 5 years because it exceeds a certain size or something of that nature. That's a very difficult issue. I'll be honest with you, I don't think those get enforced very often. You know, the 5 years comes around and the next board picks it up and someone's upset with that. Yeah, so that gets thrown on this context, and why I don't know, that gets injected into the discussion, but I think of the term grandfather as suggesting that just because something's been there for 20 years doesn't make it a legal non-conforming use. So people will say, well, that's been going on forever. But the question is this, if that use was never permitted, say that, I'm trying to think, somebody puts in, I had a zoo. I have a zoo on my property, and I've had a zoo for 30 years. I got raccoons, I got a bear, I got a duck. That doesn't make it legal. It doesn't make it a legal non-conforming use. And people will say, well, that's been there forever. Maybe, but the question is, from a legal perspective, if that's the analysis, did you have authority to put in that zoo when it was first established? It may have been there for 30 years. And the term grandfathered, people usually associate that with like, well, it's been there for 10, 20 years, but that doesn't make it appropriate. The question is usually a little bit deeper dive into whether there was a permit, whether that was permitted by the zoning ordinance of the zoning authority at the time. So here's the factors Technically, if you look at a case called LaSalle versus Cook County, these are what's known as the LaSalle factors. And here's what courts look at. So if the Planning and Zoning Commission makes a recommendation and the village board makes a decision on that zoning, here's what the courts will look at. The first thing they look at, I think that's most critical to a court, is if you make a zoning decision, how is that property next door utilized? You know, say that you guys turn down a commercial building because you're like, it's too close to a neighborhood. The first thing that the court's going to ask is, okay, on the four sides of that building or that parcel that someone wants for commercial building, what's it being used for? If it's all being used for residential, court will probably say, yeah, it was okay for the village not to grant commercial or business zoning. What's the diminished value in the property if the zoning gets turned down? How does it affect health, safety, welfare? You know, we turn down a bar, you know, the guy sues us. Can we say that, listen, we turned down the bar because it's too close to a neighborhood? It's going to affect health, safety, and welfare because there's fights, there's noise, there's accidents that occur at the bar, particularly if there's volleyball or something like that. Is that going to justify our decision? What's the gain to the public as compared to the loss of the owner if the owner does not get the requested zoning? What's the suitability of the zone use? How long has it been vacant? To the extent that it's been vacant forever, maybe that's a suggestion or an inference that it's not properly zoned in the eyes of the court. What's the public need for the proposed use? Those are some of the factors. And I think it comes down to this too is, well, this is kind of the factors, here's the criteria. The question a judge is going to ask is in his or her mind is, was this decision reasonable? Two, is it fairly debatable? If reasonable people can differ, the court is supposed to defer to the decision made by the village. I think that's what it comes down to. Do courts say that? Not really. They want to, here's the official factors. We're going to go through all 7 factors, but I think that judges will base their decision on what they think is fair, what they think is appropriate, and they'll incorporate this into the analysis. They don't want to be overturned by an appellate court saying, this is my gut reaction. But I think ultimately a judge, he or she is going to ask, is this appropriate? Is it reasonable? Let's talk about a couple more things before I leave you. Let me talk about a couple of terms. Sometimes the word contract zoning gets thrown out. And contract zoning is meant, I think, in the reference to, there was a court case in Niles years ago in which a landowner sought zoning. And what the landowner offered to give to the village was, it was like a Santa's wish list of items. I'll give you 2 police cars, I'll give you a fire truck, I'll give you this, I'll give you that. All these gifts, all these items, all this treasure. And what the court said was, and in turn, the village gives that landowner the zoning. And what the court said was this: no, that's not appropriate. To the extent that you're buying off a municipality for zoning by giving them items, that's not appropriate. That's not, you can't do that. You can't say, hey, we could use a new fire station. We'll give you approval for some sort of industrial plant or something if you build this new department, this new building for us. And what it typically means is the court's not going to throw out zoning just because something was donated to the village. It's still going to go through the LaSalle factors analysis. So the fact that someone writes a check to the village, that's not necessarily contract zoning that's going to invalidate the zoning, but it's going to cause scrutiny. And what the court's going to say is, okay, at the end of the day, is it appropriate? They're not going to defer to the municipality as much if they're getting a wish list, they're getting a grab bag of items from a developer. Before I leave you, let's talk about takings for a second. And so takings is in reference to a government taking one's property rights without compensation. And here's what the courts look to, and here's what the issue is, and this particularly occurs outside the context of annexation agreements. The idea being that if a developer says in an annexation agreement, I have 10 acres, I want to dedicate that to the village, here you go, this is going to be instrumental to my development, that's completely appropriate. That's where someone agrees voluntarily to give that to the village. The problem is outside the context of an annexation agreement where you don't have the benefit of one. And what Illinois law is very tough in this respect. They have a very high standard. They say that if you're going to obtain something from a developer, the magic language is it must be specifically, uniquely attributable to the development. And so here's the issue is, I'll give you an example. Right now, the village of Mundelein is wrestling with a proposed development that is going to generate enough kids where it's not going to fill up an entire school. But to the extent that it puts additional kids into the school system, the school district says, we want an entirely new school. So the question is, if those kids that are going to be generated by the development only take up 1/5 of the school, it's probably not going to meet that second standard that the growth from that development in terms of the kids generated is specifically, uniquely attributable to the development. It's not going to meet that criteria under the example that I gave you because the development's only producing kids who are attending school that are taking up 1/5 of the school. 4/5 of that school is not specifically, uniquely attributable to that development. So here's what's going on in the area of takings is that takings can occur in the old days. Is something where a local government, a national government, or something just took up somebody's property. We're going to take 2 acres and it's World War II, and we're going to put an airstrip out there. We need it for the Defense Department, whatever. It's a taking. They have physically taken your property. They've appropriated it for government use. That's a taking. You're allowed to have compensation for that. The more difficult issue recently is where it's a purported regulatory taking, not where the government has physically taken a property. They don't usually do that anymore, but a different situation where, hey, they're going to put some sort of requirement in the zoning ordinance or something like that where you can't use your property like you did before. A regulatory taking is what they call it. It's not physical possession, it's one of the rules. And I think the difficulty with this is first, it's ambiguous. The law is not very well developed. Some courts look at this and they say, well, maybe you shouldn't be doing this. It goes too far. The change that you made is so drastic, it constitutes a taking. But at the same time, too, we started this discussion with legislation is not written in stone. It's not the 10 Commandments. You're supposed to be able to change legislation over time. So you've got this tension. On one hand, you have courts saying if it's legislation, you should be allowed to change your zoning ordinance as circumstances dictate. Something that may have been appropriate 40 years ago, a chicken processing facility, may not be appropriate next to a neighborhood 40 years later. On the other hand, too, when these courts say, you made a change to your zoning ordinance to make it more restricted, it goes too far, it's pretty subjective. So the tension is, first, which thought prevails, and then 2, the difficulty with these takings claims is that if you lose, you get to pay the attorney's fees. That's a scary thing. You better be confident that if you're going to do something that arguably goes into the area of a taking, you better have the confidence to be able to fight it and win it, because oftentimes insurance carriers don't cover this type of thing. If a car gets in an accident and says the village didn't design its road correctly, or the stop sign wasn't an octagon, we want something else, some issue with the village, that's covered by insurance. A lot of the time in the context of civil rights with takings, that's not covered by the insurance. And that's why it's a particular tricky thing, especially when the case law is not very well developed. You read a case by the Supreme Court that's 50 pages long, and sometimes you're left scratching your head saying, I'm not sure what they said. At the same time, too, the importance of the comprehensive plan is, say that the village ever wants to take over property, it has to be set forth in the comprehensive plan. The courts say we want planning, we want planning, we want planning. So this is a tricky area. I don't think it's very well developed, and frankly, it's kind of intimidating in the sense that if you gamble and you're wrong, that could be a huge liability for the village. That's why we're very careful with these.
I'm very confident in the comprehensive plan. We'll put together a salad.
And if the village ever decides to amend it or overhaul it, we do have a public hearing. So there's supposed to be a public hearing before some body such as Plan and Zoning or the village board before that gets adopted. Okay, so that's it. Any questions? How are we doing on time?
Michael, I just want to thank you very much for the presentation.
Oh,
Very nice.
absolutely.
You did it off with hardly any notes, so that's very exciting. I just got a quick question for Andy, because I can't find it. A lot of people have been complaining about drones. Do you have anything, city ordinances about drones or use?
No, we do not. No. As it's developing one there.
Okay, thank you.
And the difficulty in the area is to what extent does federal or state law cover this area that keeps us out? That's the question.
Windows. and
Right.
things like that.
Yep. All right.
Somebody is concerned about someone driving a drone on their property or something like that, tell them all night.
Okay, thank you very much.
All right. If there's no other questions, thanks, gentlemen. Thanks, everyone, for listening.
Like to entertain a motion to adjourn. It'll tell you more of the business.
I'll make a motion to adjourn.
All those in favor? Aye.
Aye.
I will adjourn this meeting then at 6:49.
I didn't think it'd be up to dinner.
Yeah, that's very.
Larry, I know we're not.
Luke has an egg time.
Well, great about a minute.
Bad, I don't like it. Always another one.
So, our next. How are you? How are you been?
Closer to the front, better you're on camera.
Keep going. Good.
I'm gonna stand up. I'm gonna be standing. I'm gonna have to. It's gonna be a little crazy.
How are you doing?
I don't blame you. I don't blame you.
It was so long.
That's definitely, Hey, how are you? Good to see you, brother.
Sure.
How you doing?
Just like I had to tell them.
That's a good one for you.
I was in some case, I know where it was. And then someone got up to me and they were like, I was like,
said, why is it?
Solution, whatever, because it is. I did, yeah. I know the guy, I don't know him. So I think he's like, okay, fair enough. I know, well, actually. Blah, blah, blah. Good, good to see ya. In that building. Maybe. This is all good. Strong those are. Oh, not. Perfect. Yeah. Well, you know, those video treats. Grab it all. I don't feel like